What is Jurisdiction Simpliciter? Jurisdiction Simpliciter is an analytical process that is undertaken by the court to ascertain whether or not the court has a requisite jurisdiction to hear the matter that is presently before it. As such, the court is seeking to ascertain whether or not there is a real and substantial connection between that particular court and the subject matter of the litigation. The court seeks to prioritize order, stability, and predictability by relying on objective connecting factors for the assumption of jurisdiction. Justice J.T. Neilson in the Alberta Court of Appeals decision Deadman v. Jager Estate framed the test of Jurisdiction Simpliciter as follows. The test for Jurisdiction Simpliciter is intended to establish a minimum threshold for the assumption of jurisdiction. When an application to challenge jurisdiction is brought, the onus is on the plaintiff to establish Jurisdiction Simpliciter by demonstrating the presence of presumptive connecting factors, which establish a real and substantial connection between the facts on which the claim is based and the chosen forum, entitling the court to assume jurisdiction over the dispute. The defendant can rebut the presumed jurisdiction by establishing facts which demonstrate that the presumptive connecting factors do not point to any real relationship, or only a weak relationship between the subject matter of the litigation and the forum. If the defendant fails to do so, Jurisdiction Simpliciter is established. It should also be noted that Jurisdiction Simpliciter is the precursor to a litigant's application for forum nonconvenience, as the court must first determine if it even has jurisdiction to hear the litigation before it proceeds to consider if there is a more appropriate forum, which is the legal test of forum nonconvenience. To understand the legal concept of Jurisdiction Simpliciter, one would be well served to read the words of Supreme Court Justice Cote in the Supreme Court of Canada decision in Harrods.com v. Goldhar, as well as the words of Supreme Court Justice LaBelle in the Supreme Court of Canada decision in Club Resorts Limited v. Van Breda, that Justice Cote placed considerable emphasis upon. The Jurisdiction Simpliciter analysis is meant to ensure that a court has jurisdiction. This will be the case where a real and substantial connection exists between a chosen forum and the subject matter of the litigation. The real and substantial connection test at the Jurisdiction Simpliciter stage prioritizes order, stability, and predictability by relying on objective connecting factors for the assumption of jurisdiction. In defining the content of the real and substantial connection test for the assumption of jurisdiction, this court was faced with a choice between an approach based on objective connecting factors and a case-by-case approach. This choice was characterized by the tension between predictability and consistency on the one hand, and fairness and efficiency on the other. Ultimately, the court decided to prioritize order and predictability at the Jurisdiction Simpliciter stage in the following terms. Given the nature of the relationships governing by private international law, the framework for assumption of jurisdiction cannot be an unstable, ad hoc system made up on the fly on a case-by-case basis, however laudable the objective of individual fairness may be. As Justice LaForest wrote in Morgard, there must be order in the system, and it must permit the development of a just and fair approach to resolving conflicts. Justice and fairness are undoubtedly essential purposes of a sound system of private international law, but they cannot be attained without a system of principles and rules that ensures security and predictability in the law governing the assumption of jurisdiction by a court. Parties must be able to predict with reasonable confidence whether a court will assume jurisdiction in a case with an international or interprovincial aspect. To achieve this order and predictability, the court opted to rely on a set of defined presumptive connecting factors at the jurisdiction simpliciter stage. This objectively ascertainable and relatively low bar to establish that a chosen forum has jurisdiction on a prima facie basis reflects the constitutional imperative underlying the jurisdiction simpliciter stage as described in Van Breda. From a constitutional standpoint, the court has, by developing tests such as the real substantial connection test, sought to limit the reach of provincial conflicts rules or the assumption of jurisdiction by a province's courts. In its constitutional sense, it places limits on the reach of the jurisdiction of provincial courts and on the application of provincial laws to interprovincial or international situations. The constitutional purpose of the jurisdiction simpliciter test is to establish a minimum threshold for the assumption of jurisdiction in order to prevent improper assumptions of jurisdiction. Its objective is to delineate circumstances in which a court has jurisdiction, not circumstances in which it should exercise it, which is the purpose of forum nonconvenience. The prioritization of order and predictability at the jurisdiction simpliciter stage is also consistent with the principle of comity, which is central to Canadian private international law. Justice LaBelle also discussed whether a court would be limited in hearing only that part of a multi-jurisdictional claim that can be directly connected with the jurisdiction. In holding that a court would not be limited in such a manner, he explained that, quote, the purpose of the conflicts rules is to establish whether a real and substantial connection exists between the forum, the subject matter of litigation, and the defendant, end quote. Where a real and substantial connection exists, quote, in respect of a factual or legal situation, the court must assume jurisdiction over all aspects of the case, end quote. Yet it must be remembered that even if the court determines that it has jurisdiction to hear the litigation, the litigants might well seek to assert forum nonconvenience and necessitate this further test, which is subject to its own legal analysis and the subject of other YouTube videos that we present. Thank you.